Good afternoon, Mutas. So what I will do is maybe just share a few pointers. I don't have the entire rule book, so I'll just share with you one or two pointers that would help you in this journey, not only for this mood, but maybe even in other moods. And then we see how if we can take questions, and then we can wrap it up. So the structure of my presentation will be, I'll probably just make a brief presentation, maybe about 10 minutes max. And then I will invite question and answers, and then we see how we go. All right. So my name is Lando. I am an advocate of the High Court of Kenya. I practice law in Nairobi. I also teach law at the Riara University, at the Riara Law School, where I serve as the dean there. So it's interesting to engage with students. So you're all my students, the Mootas who are students here. So karibuni sana. Now, just a few things. One is, I'll start with the written memorials, and then we'll get to the oral presentations. So a few things about your written memorials. One is the structure of your document is very important. The way it looks and the way your arguments are ordered is very important. Make sure that your structure is, the reader is able to follow your thought process in the structure that you have adopted. Okay, so if you need to have a table of contents, make sure you have a table of contents. Subheadings, make sure you have subheadings. And then listing the issues, make sure your issues are listed properly and that they are handled properly and effectively. Okay. Make sure you what is it called? Legal precision. Make sure you are actually arguing on the basis of the law and the correct law. Okay, so don't place your arguments based on some law that doesn't exist. This is a moot, this is a legal process. So you must have legal precision, because you can have the best looking memorial, but if you are not okay in terms of the law, then you're in trouble. All right. Make sure you use authorities. I know in the international setup, the principle of judicial precedent doesn't apply, but where possible, if there's precedent that applies, then apply that precedent. So use your authorities, case law, journal articles, textbooks, writings of publicists, reports. All those are authorities that you need to cite and you need to use. Okay. In terms of structure, the written structure, I usually, for persuasive writing, I prefer that you use what I call CREAC, C-R-E-A-C. Whereas the first C stands for conclusion, the R stands for the rule or the law, the E is explaining the law against the facts, and the A is analysis, and then you start with a conclusion. So for example, if you have, this is a different scenario. If your client has been charged with murder or with offense of theft, the first thing the judge should see is when you're addressing the issue. So the first issue is whether my client is guilty of murder, hypothetically, yeah. Now, the first thing the judge should see is my client is not guilty of murder. And then you now go and analyze the facts and the law on murder. And then the last thing the judge should see is my client is not guilty of murder. So perfect. So for the written memorial, the structure, when you're handling the issues, I don't know how you have done it before, but what works for me when I go to court is I start by saying my client is innocent, and then I explain to the court the law on whichever offense it is against the facts, and then I conclude again by saying my client is innocent. So we do like a sandwich. There are sandwich looks. There's a bread on top, and then there's filling, if it is eggs or bacon or whatever, jam in the middle, and then at the last, down here, it's another slice of bread or a burger, right? So at the top is your conclusion or your position is that my client is innocent. And then inside here is now your analysis. And then the last thing that holds the arguments together again is my client is innocent. So this is the same thing you should use when you're doing persuasive writing. All right. So for the written memorials, structure is important. Try as much as possible to use that sandwich method, where you start with the conclusion, and then the law, and then you analyze the law and the facts, and then you conclude again with your position. Then secondly, I've said legal precision, use the correct law, cite authorities. Okay. And then third thing is, of course, your structure, how your work looks. Okay. Have you provided the proper spacing? Have you justified your text so that it reads nicely in a block? Do you have subtitles or is subheadings? You know, does your work look appealing to the eye? You know, when someone looks at a memorial, does it look, you know, good, right? Yeah. And then, of course, English, grammar. Okay. Please use the correct English. Don't use emojis. Don't use slang words that not everyone is aware of. Okay. So just use proper legal English. Okay. For the most part, avoid the use of too much legalese or these Latin terms that we keep throwing around. Res ipsa, ipso facto, suo motu, all those things. You know, try as much as possible to just be simple, but not too pedestrian. Proper English, but not too pedestrian English. Don't throw in too many Latin words. Yeah, because sometimes the people who may be judging the moot may not necessarily be practicing lawyers, or may not even be lawyers. They may be people who are experts in something else, but not necessarily law. So don't throw in too much of those Latin terms. Yes, so that is it for the memorial side, for the oral side. No, for the written side, sorry. Now for the oral side, I have like a long list of maybe 8 things. One is you have to be familiar with the facts or the problem. You cannot make an oral presentation if you do not have the problem at your fingertips. So you need to know the problem inside out, because sometimes the judge will throw a question trying to check whether you are familiar with the facts. And so if you're not familiar with the facts, then you're caught there mumbling and stumbling. So the most important thing is be familiar with the facts of the case. Okay. Secondly, moots are generally designed to look at gray areas where the law is not very certain or where the law is unsettled. Okay, so in a moot, you may not have a clear legal position. You know, the designers of moots don't design moots to make them easy that this one is clear cut 100%. For the respondent or for the applicant. No, moots are designed to make you think and stretch your legal mind. And so appreciate that in a moot, you may not have all the answers. Okay, so just stretch your legal mind as far as possible. Yes, and then also go with the thinking that in a moot, there is no clear position in law. It's unsettled. So the moots are designed to generate thought in terms of those emergent areas of law. The third thing is mode of address to the court, mode of addressing the court, courtesy to the court. Master the way the court prefers to be addressed. I'm sure it is in your rules. Is it your lordship or your ladyship or your honor or my lady or my lord? Or is it honorable members of the panel or your excellencies? You know, it depends on the mode of courtesy that you need to use when you are addressing the tribunal or the court. And so use that. There's also the courtesy to your fellow counsel, the guys who will be appearing on the other side. All right. So if you're making reference to the respondents or making reference to the applicants, right? Make continuous reference to counsel for the respondent has said this. counsel for the applicant has said 1, 2, 3. Don't start saying, oh, they have said this and they have said that. Don't refer to them as they, like it's a pedestrian thing. No. Address both the court and opposing counsel with the courtesy that they deserve. And also your co-counsel, address them as well with the courtesy that they deserve. If you're the first one to speak on behalf of your team, of course, you will need to introduce your team. You'll need to say, for example, my name is Lando. I am counsel for the applicant. I appear alongside so-and-so and so-and-so, who are also your co-counsel, So you need to also introduce your co-counsel. And then, of course, you will need to tell the tribunal how much time you will take. So you'll say, and what issues you're going to address. So, for example, say, my name is Lando. I am counsel for the applicant. I am appearing alongside John and James, who are my co-counsel, for example. Then you say, I will address issue 1, 2, 3, and then John will address issue 4 and 5, and James will address the rebuttals, for example. And you also inform the court how much time you will take. I will take 2 minutes to highlight the issues, and I'll hand over to my counsel, who will take 2 minutes, and the other one will take 1 minute, So again, courtesy, mode of address, and budget your time accordingly, right? The next point is speak audibly, speak slowly, speak clearly, okay? Speak audibly. Make sure that the court is able to hear you, okay? Yeah, and speak slowly. Some of us, when you get nervous, if you want to figure out whether Lando is nervous, Lando starts speaking very fast. That's just how I am. If I'm nervous, I'll speak fast. So for people who are nervous like me, you need to think, and then you make a conscious effort to slow down your brain and speak slowly. Because sometimes the judge is also following your argument, and they need to, some of them are taking notes. So they may need to also follow what you're saying. So number one, speak slowly, not too slow like snail slow, but speak slowly, not too slow. Speak audibly and speak clearly. Okay, there's no need to adopt a British accent or an American accent. If you have a Kenyan accent like me, just speak it as a Kenyan or as a Ugandan or as a Rwandese or Burundian or Tanzanian. English came by ship, so let's not try and fake an accent that, oh, I'm trying to speak like I'm British and all those things. No, be authentic, be yourself. Okay, so speak audibly, speak slowly, speak clearly, and then maintain eye contact with the tribunal. Okay, there's something about eye contact that speaks volumes. All right, I've attended some moots where the participants are reading from the memorial. So half the time you're like this. The respondent submits that the tribunal does not have jurisdiction because, you see, when the mooter is reading, it means you don't have a command of the facts, right? So do not read. Maintain eye contact with the tribunal. And the good thing with mooting, you may have an even number or an odd number of judges. And there's usually the nice judge. There's usually like a nice judge somewhere. So try and figure out among those 3 judges, who has a friendlier face. There's always one who has a friendly looking face, and you can maintain eye contact with them. And so you just shift eye contact between the 3 of them or the 2 of them. Or if it's one judge, too bad, figure out how to maintain eye contact. But at all costs, do not read. Do not read from your notes. You may have short notes just to refer to briefly, like this, but do not spend your entire time just reading from A to Z. No, don't do that. Number one, because you will, it will cost you time. Number 2, it will cost you points and marks. Okay. The other point is, do not lie to the tribunal. If the tribunal asks you something about the facts and you honestly forgot and you don't know, be honest to the tribunal. Tell them, I stand guided. I am not aware of that. I am not familiar with that. And then you seek guidance from the tribunal. But do not lie to the tribunal. Do not invent your own facts. Do not invent your own case. Yeah, those things of being dishonest. Don't do that. Do not lie to the tribunal. Okay. Yeah, so if you do not know, just ask the tribunal for guidance. They know that this is a learning process, and so they will guide you. Okay, of course, it's a competition, but they will, at the end, guide you. It's better to make a mistake during mooting than to make a mistake when your client is on death row, and your mistake will either send your client to hang or not. So it's better to make the mistake now when you're still able to guide you and provide you with that support. The other thing, of course, is courtesy to opposing counsel is very important. Don't call them liars that, oh, these liars have come to lie to the tribunal, etc. Don't use harsh words when you are engaging or when you're referring to opposing counsel. They may be wrong on all counts, on all fronts, but maintain some level of decorum. Okay, don't come off as this very aggressive, abrasive human being. Deal with the facts, deal with the law, but still maintain professional courtesy amongst yourselves and the other tribunal, no, and the opposing counsel. Then the other thing, I'm heading toward the last one. Teamwork. Okay. One of the things that is looked at when you are assessing a mooting team is teamwork. These people able to work together as a team, or are you depending only on your orator or oralist, the one who knows how to speak very well? So you need to it's called what? Figure out a rhythm of how your team works. And funny thing, don't say that I am only going to handle issue 1 and the other people will handle issue 2 and 3. And so you are not familiar with issue 2 and 3, you are only familiar with issue 1. No. All of you, if you're 3 of you mooting as a team, all of you should be able to argue on all 3 issues. Okay? And the issues that if you are for or against, you need to be able to argue both sides and on all issues. So do not let it be that the lead counsel is the one who knows everything, then the other two say, I'm just a researcher, me, I don't know the issues. No. All of you are part of this team. So the judges need to see how this teamwork is evident. So you can even refer to the points that have been raised by your colleague, your co-counsel. And so if you're maybe rebutting a point or you are closing the argument, you say, counsel so-and-so said this, so-and-so said this, my co-counsel said this, and therefore on the basis of all this, our conclusion is ABC, So it shows that there is some teamwork happening. Okay, so don't let one person only handle everything. Then the last thing is, this is a learning experience. It's also a chance to have fun and to network. So do not see it as the end, as the beginning and the end of life. It is not. Life moves on after mooting. Okay, it's a competition, yes, but it's a chance for you to have fun, to generate networks, and to learn. And that happens for everyone. So see it as a chance to learn, have fun, generate networks, and just build yourself. Okay, we are here to, so whoever wins, good, but winning is not the end goal. Of course, you want to win, but there's more to mooting than winning the moot. All right. So in summary, 1, familiarize yourself with the facts. 2, moots are designed for gray areas, so just know that. 3, courtesy and mode of address to the court. 4, speak audibly, slowly, clearly. 5, if you do not know, stand guided and ask for guidance. 6, do not lie to the tribunal. 7, maintain eye contact. 8, do not read from your memorial. There you do full-time reading. Don't read. Just address. address address the court on the issues that have been raised. And then the other one, of course, is there will be instances when the judges will throw questions at you to try and throw you off balance. Okay? Answer the questions respectfully and then ask for permission to proceed. So if a judge asks you a question in the middle of submissions, then you can rephrase the question so that the judge may clarify. So you can say, for example, if the tribunal may want to clarify for me, what I understand this question to mean is 1, 2, 3, 4, 5. Is that correct? The judge says yes. Then you submit based on facts and the law. When you finish with the submissions, then you ask the tribunal, with the tribunal's kind permission, may I proceed? Okay, and then the judge says, yes, kindly proceed, and you go. Okay, do not engage the tribunal in a match where you're arguing with the tribunal. You feel you're very correct and you need to put your point across, and so the tribunal is wrong. Sometimes the tribunal just wants to throw in things to try and keep you off balance. So you need to master that streak. You handle the question as quick as possible, and then you request for permission to proceed. All right. And again, stick within your timelines, budget your time accordingly. Yes. I don't know if I've answered all your questions, but that is a brief snippet of what happens in mooting. And I don't know if there are any questions that you'd wish to ask. If so, then I think I can take a few, subject to further guidance by Barbara.
Thank you very much, Barbara, Dr. Nando, the other facilitators, Mooters. I'm very sorry at this point to say that I missed out on the first 20 minutes of the introduction part. But sorry, let me have my video on. I missed the first bit of it, but I'm happy that I have followed what Dr. Nando has presented. And if I'm well guided, Barbara, I'm also to present to the Mooters how to go about their oral presentations. So thank you very much. With that, I will proceed, and I'm able to join properly now, and I'm heard. Mooters, I want to congratulate you for having made it this far. You have been through a process well out. Start on the written petitions, I think that you have gone through. You have also been taken through the rules of the Moot competition. So we are happy to guide you on the oral presentation, as you know. And for me, I'll just put a few pointers. Probably I may summarize what Fernando has already presented, but I think it's important that as you prepare, even fast and you are prepared mentally. Are prepared mentally, because the mental fitness is what will be presentation. And with that also goes your confidence, goes with your way of dressing, your way of dressing. That to appear bold. And the other point, your way of it. How do you want to the court? You must learn that the way you help the court, what will make of your presentation, because you have the attention of the judges. And how do you have the attention of the judges is to ensure you are addressing the court in the proper manner and you are captivating them with your address. So you must ensure as you appear there you are captivating the court and making a proper address. And in making your proper address, I know Dr. Nando has spoken about the language, and I'm going to reiterate that as well, because we have come a long way as a legal profession. Because initially, in the olden times, even in the last century, lawyers were known to have that language that was very, very mesmerizing, and they communicated in a way that everybody was like wowed by the way they appeared, the way they talked. But remember that we are in an age where information goes out so fast, and you have to communicate in a very simple and plain language. So you must ensure you are using proper grammar. I've noticed that in the modern times, because of a lot of use of technology in social media, we have lost the grammar bit of communication, and people use a lot of jargon, a lot of language that is not known to other people. And you must ensure your language, whereas you're communicating as a lawyer, it must be simple, plain English, which is devoid of grammatical mistakes and is grammatically sound. So there are small things, they may look small, and I know lawyers, we always talk about shall, will. You must know how to present yourself or how to speak when you're speaking. Is it my client was, my client had, my client have? You know, there are all these mistakes that are made nowadays, and they sound absurd when a lawyer who is well trained in the profession, they make such simple but very unmistakable mistakes. Then there's the issue of time. When you are speaking, the issue of time is very important. You have prepared your brief very well, your memorial very well, but you must know how much time has been allocated to your team. And how you allocate that time amongst yourself is very critical, because you must show, as Dr. Nando said, you must show that teamwork. You've been allocated time, but I think in an opening address, you must show that, you know, you have also put that into your presentation, and you must tell the court that we have so many minutes and we are going to spend this time as follows. So that in your opening address, you have a very strong presenter coming out. Remember, you must present your case. You must show you've understood your case. So at the point where you are speaking to the court in an opening address, you must ensure you say all the important things that must be said. And whoever picks over from the opening statement is somebody who is able to address the courts on now a deeper sense, bringing the court to the case, the issues, bring out the issues properly, an analysis which is well supported by authorities and all the statutes you want to bring out. And then ensure also that at the end, you're bringing out and you're thinking forward about the questions that may come up, so that you address the court on that and say that you have gone through the issues, and if those issues come up and the court asks any question, you'll be ready to answer those questions in a manner that shows that you have a grasp of the issues and that your team went out to do a scenario mapping of what could happen if this issue came about. And that means your team must be so well organized and show the court that that organization is what has brought out the teamwork and a successful presentation. So who begins with the opening address to the court is very important. And as I said, who takes over must equally be strong to support that opening address and ensure you are wrapping up also strong, so that in case there's any issue to rebut, you are ready to rebut. Then there is the style of speaking. Again, I think this is an issue that is very critical for lawyers. Are you clear? Are you understood by the court? And are you precise in your presentation? So don't beat about the bush. Don't bring about issues that were not there in the first place. Stick to the issues in the mood, because then that means you are focusing on the problem, and that you are, if there's any gray area, you are addressing that before the court in a manner that is quite clear and concise. And then the other thing in presentation is that as you make your presentations, please do not appear as if you are animated with a lot of use of your hands, and just look like you are all collected, you are composed, so that there's that capture of the court by way of, looking at you and looking at what you are and how rather you are presenting yourself before the court. So don't appear animated. And of course, as Nando said, people would always be nervous, but remember that the court wants to understand you in a manner that you're focusing on the issues and not on yourself in your demeanor before the court. The other thing that is also very important is for you to maintain respectful language, whereas you have respect to the way you are addressing the court in the proper manner, you must also respect your opponents and use language that is respectful and cordial. Even where you know there is a contentious issue, you'll find a way to put it out in a very, very respectful manner. Remember that we have all been trained in an adversarial system where you have to go and show your opponent that they are wrong and they are not putting out reasonable arguments. However, in a moot court, I think being a competition, you need to come out as knowledgeable and somebody who is skillful, that you have learned the art of even speaking to your opponent, even when there is a hot issue, so to say, and you will be speaking in a manner that shows knowledge, shows confidence, and brings you out as a person who, even in the heat of the moment, you are able to circumvent so many issues, but bring out the issues in clarity. So I think I had a few of those issues to present in terms of how you appear. And of course, the teamwork cannot be overemphasized, because that is why you are there in the moot competition as a team. And you must show that from the top, the lead counsel, to even the research assistants who are helping you, to those who are making presentations in terms of the issues that have been laid out, everybody understands, everybody is on the same page, understanding the issues and bringing them out before the court. And it's a winning formula for all of you. So I think I may have sounded like I was repeating myself, but I think even though technology has come to make things very easy for all of us, I think for the legal profession, we still remain to show your knowledge, to show your skills and your expertise in terms of the legal way of thinking, and even the legal way of approaching the bench and making your presentation in a successful way. So with those few remarks, I will be ready to take up any questions on how to make a good oral presentation. Thank you, Barbara. Thank you, Mootas.
Thank you, Ms. Lillian, for that knowledge and insights on oral submissions. I noted the main things on oral submissions, and I noted that teamwork is everything. How you coordinate as a team and how you manage your time is everything. Why delivering oral submissions in the moot court. And also I noted that composure is everything. You don't have to be fast. You don't have to be also overconfident. If you have not understood anything, it's okay to ask, though it's a competition. So don't overestimate how confident you are, and ask when you feel like you're not understanding what the judges are saying. Also, I noted that language is everything during oral submissions. You don't have to use jargons. Be simple while speaking and communicate. Don't use jargons. Don't adopt an accent while delivering oral submissions. So those are the key points I noted on oral submissions, and I'm really grateful for that knowledge, Miss Lillian and Victor. I appreciate, on behalf of Unwanted Witness, I would like to appreciate you for sharing your expertise with us. I see our partner, ICJ Kenya, has a representative, and he has joined us. So I would like to give him some time to submit or deliver some remarks. Mr. Ian Wallace, welcome, and please take over from there and deliver some remarks or submissions.
Hello, can everyone hear me? Hello?
We can hear you.
Okay. Good day to everyone. I would like to first thank everyone for, especially the organizers for this Moot, for giving us this bootcamp session. Very informed. I found it very helpful, especially for young Mooters who are, just starting into this process. It's not exactly my first time, but I can always learn from a bootcamp. I think you can always sharpen yourself and make yourself extremely better. So extra thanks for the bootcamp session. I represent also from JQuad campus, and special thanks from them as well. We're a very growing meeting community, and it's very nice for us to be involved with these other moots from other places as well, and to get our community growing and to invite more people to participate in moots. So a special thanks from JQuad community. Aside from that, I would like to also thank Mr. Lando, Lillian as well, everyone who is basically like acting as hosts for these meetings. I've learned a lot from today, and I'm also going to take some of this knowledge that we've had here today and take it back to JQuad, and try to empower a lot of our students and try to add and grow the Moot community. So you can't imagine how much thanks I have for this kind of lessons and this kind of boot camps. So I don't really have that much to add. I think most of everything has been said, but otherwise, thank you guys so much. We'll be taking a lot of this into consideration, and I hope we have a very competitive and very entertaining legal competition come D-Day. So thank you very much.
Thank you, Mr. Wallace, for those remarks. And thank you for joining us today on this session. This is the time when we should be asking questions. I really want to encourage the Mooters to share your questions right now. Any inquiries or the areas we've covered, feel free, don't feel shy. Share them on our WhatsApp group, and our facilitators are ready to address them. You can also raise your hand. I will see you and give you an opportunity to ask about anything. This is our last phase, remember, and we really want to make the best out of it. I hope we've been noting. I hope we pick the key points, and let this Q&A session give you an opportunity to ask about anything before we even head on to the next stages of our Moot competition. John Isaac, I see your hand is up. You can raise your question right now, and we have it addressed.
Thank you so much. Can I please confirm being heard?
No. Yeah. We can hear you.
Okay, please. Thank you so much, Mr. Lando Victor and Miss Mahiri Lillian. My question is around still oral submissions, and I'm seeking to be guided whether I can depart from my written submission, not entirely, or even add something orally into my written submission, which would make it be like submitting at the bar. I wonder if that's possible. Thank you.
Do we have any other question? Thank you, Isaac, for that question. It's a good one, and it will be addressed. I urge everyone to send in their questions right now, and we have them addressed before we even conclude the session. Kindly raise up your hand. I will see you and give you a chance to ask. Or you can even share in our chat room or WhatsApp group, or even on our WhatsApp, on our social media platforms. You could just comment in the comment section and submit your question. We want to have an engaging session, and we aim to answer you and equip you with all the knowledge that you want to excel in the competition. I can't. I think I'll direct Isaac's question to Miss Lillian, and we'll wait for more questions to come through. Miss Lillian, I think you can respond to Isaac's question.
Thank you very much, Isaac, for asking this very good question. And I'll try as best to look at it objectively. You're asking if you can, by way of, depart from, if you can give an answer during your oral presentation that is not in your written, if you can depart from that. I think for me, I would say you can only depart from that only where you are explaining or clarifying an issue that you have written, and probably it raises questions from the bench. So probably the judge wants to seek, if you really understand that issue that you've put down, and may seek a clarification. If it is probably a law you are applying and you have analyzed it in a way that is not clear, the judge may seek a clarification. So by way of explaining, you may go out of your written submission. And I can't think right now of an example, but I know there should be, where you can clarify a matter, however, to strengthen your position or rather the position that you have written, and that should be allowed. But if you go to an extraneous issue that is not part of the issues that you have identified, and it causes more confusion and does not seek to clarify the written issue, then I would think you may have to think twice about making an oral presentation to that level. So remember, what you write is not always what you may wish to say, but seek to harmonize your position by way of clarifying and not confusing the bench. That would be my brief explanation.
Thank you, Ms. Lillian, for answering Isaac. I hope, Isaac, you understood and your question was addressed. I got another question on here on WhatsApp, and Penny is asking, how does she improve her confidence? Or how does she overcome the fear while delivering oral submissions while in the moot court? I will direct this question to Mr. Victor, and I'm urging everyone to even submit more questions, and we have them addressed right here. Mr. Victor, are you there? I see. I got another. There's another hand up. Patrick, please go ahead and ask your question. Patrick, you can ask. Yeah, Patrick, you can unmute your mic and ask.
Thank you, Madam Barbara. Thank you, Mr. Victor and Madam Lillian for the wonderful presentation. My question is, how best can I request for addition of some few minutes in an event where my time elapses before I'm done with my submissions on the specified areas of which I wanted to submit on? Thank you very much.
Okay. Let me answer the first question first, and then maybe I see if I can attempt the second one. The first question was on how to boost your confidence when you are appearing before the tribunal, before the panel. I think the best way to do it is through practice, over and over again, to moot as many times as you can, so that you are able to just get used to being in that space. That's the only way. That's one of the main ways of it's called what, addressing that kind of confidence that you need. I remember the first time I appeared before a court of law. When you are admitted as an advocate and then now you're appearing before a court of law, you fumble like crazy, and it is okay. But then I found a judge who was very understanding, and he helped me argue my case nicely. So it just comes with practice. It just comes with practice. And then, of course, there is the notion that even the expert one day was a beginner. Someone who you think is an expert, one day at one point, they were a beginner somewhere. So no one is born an expert. So these things come with practice, come with exposure. A few things you can do is just master your facts, master the law. Once you're confident with your facts and the law, as I said earlier also, look for one member of the panel who has a friendly face, if you're lucky to have one, and then maintain eye contact with that person. The other thing is maybe just familiarize yourself with the environment, maybe 1 or 2 days prior, or even on the morning of. You can just take a walk and look at the venue and see how it looks, and just familiarize yourself with a couple of things. But the main thing is confidence boosting is, one is to practice. The other thing is maybe to watch several videos of other people mooting and see how you can hone your skills as you moot. And then just know that mooting it's a competition, yes, but also a learning opportunity. So that is what I would say. With regards to the second question, in terms of asking for more time, it depends, because the strict timelines means that if you're given more time, then it would be unfair on the other teams, because the other teams have also maybe have not been given the time. Haven't been given additional time. So the best strategy is budget for the time allocation that you will be given. I'm sure you know by now how long you will have. So as you practice so that you are able to exhaust all your points within the time allocation that you have. The only time in my thinking when you'd be allowed to ask for additional time is if, for instance, the judges have asked you several questions which have them eaten into your allocated time. If you had 5 minutes, and then out of those 5 minutes, 3 minutes have been taken up by questions and after question by the judges, then of course you can just make a request to the court and say, if it may please the court, kindly request for an additional 2 minutes, and see what the court says. If they allow you, then that is fine. If they don't allow you, then it is okay, because the judge is the master of the court. The court is their court, so they have the discretion whether or not to grant you additional time. But if you didn't budget for your time wisely and you're asking for more time, I don't think you'll be granted time. But if you've been questioned severally by the tribunal and it has eaten into your time, then I think they would understand and allow you to make your presentations on the issues you need to raise. Thank you.
Thank you, Mr. Victor, for that clarity and answering those questions. I hope that. Ms. Frida, are you saying something?
Yeah, I wanted to make an addition to the first question by Penny on improving your confidence, if you'll allow me.
Please.
Yeah, I wanted to tell the Mooters that it's important as a team to have sessions where you make a dry run, or you do a dry run of the presentation and critique each other on the way you're presenting and the way you appear. You all know each other, you know how you speak, so you'll be able to tell a colleague that you are shaking, you are not being coherent, so that with time, even as you do some peer review, you are able to gain confidence as the competition draws near and overcome your fears of stage fright and all that. Whereas Victor has talked about practice, you can practice now through doing presentations amongst yourselves. You stand and just imagine you are before the court and present your case and keep on critiquing and improving on how you're making your presentations. So I think that's also very important. And on additional time, I don't think it would be wise for any of us to advise you that you can request for additional time, because this is a competition. You go within the provided time, you plan for it, and if you don't get enough time, then that means you must close your case within that time, so that it is known to the judges that you know how to manage your time, you have managed your case properly, you have managed your team, and therefore time is of essence and you must deliver in the shortest time possible. Thank you.
Thank you, Ms. Lillian, for that clarity. I noted some key things. I hope the Mooters were also noting down, and you understood, the people who asked those questions understood, and before we even, we are almost closing the session, but before we even get there, I'd like to ask Ms. Frida, the head of the Moot Secretariat, just in case she has any question or any comment.
Thank you, Barbara. I really don't have a comment at this particular time. The areas I really wanted to emphasize, our dear facilitators have ably hinged on them. That even earlier I did mention in my opening remarks. And then also I am happy that the Mooters on the court have also asked questions, especially in regard to the fears. It is very normal to fear. Stage fright is very normal, but then it is not normal when you don't handle it. So I like what our dear facilitators have hinged on. Practicing, you really need to practice. And the element of actual dry runs, like Miss Lillian has ably shared, is very critical. You really need to you can actually stand before a mirror and begin presenting as well on your own, but also as also as a team. So it has to be at a personal level, but then also even before your team, who will obviously do some kind of peer review for you to improve. Yeah, so basically, most of the areas have been ably emphasized, unless our motors have have more concerns that our facilitators, I know, will be more than happy to address. So over to you, Barbara, again.
Thank you, Frida, for those remarks. We are almost concluding, but before we even conclude, I would like, on behalf of Unwanted Witness, I would like to send my appreciation to Miss Lillian and Victor for sharing your expertise. We're really honored, and we thank you for honoring our call and our invitation for this session. We are really grateful. And I hope the Mootas, you took note of everything, you took note of all the tips that were shared, and you're going to put them in practice. Let us go and do our dry runs. Let us go and start practicing in front of the mirrors like Miss Oral.
Hello, do you hear me?
Now we can hear you, but Barbara went off.
Oh, Barbara, so apologies. She's trying to get back. But I saw a hand from John. So John Isaac, please, you're welcome to make make your question.
Thank you so much. Can I please confirm being heard?
We hear you loud and clear. Please proceed.
Okay, please. So in regards to time and how we plan for the same, do we only, in case probably I'm appearing for the applicant or whichever side, am I supposed to budget for my time to include the time for rebuttals, or there is extra time accorded for rebuttals, just in case? Thank you.
Do we have any other more questions? Okay, if we don't, I wish to welcome any of our facilitators to chip in and address John's question. Over to you, Dr. Lando and Ms. Lillian. Maybe we can start with Dr. Victor.
Okay, thank you. You will need to budget for everything in terms of time allocation. Budget for your issues as well as rebuttals, so that because there's going to be a timekeeper who will be monitoring how much time you use. So that's why it's important at the outset, the person who is addressing the court at the first instance should inform the court how much time you're going to take in total. So you say, I have 25 minutes, and therefore I will take 5 minutes for this, 5 minutes for whatnot, and 5 minutes each for rebuttals, so that you are within your time allocation. So don't exhaust your time, and so that you don't have sufficient whatever for rebuttals. Okay, and then also note that the court already has your memorials. So what you need to do is just highlighting what is in your memorials, and in particular the main issues that arise. Okay, so you need not say everything that is in your memorials. Speak to the main emergent issues. Speak to the little bit about the facts and the law and your arguments. Do not repeat the facts again afresh. The court is aware of the facts. So that is one of the ways of saving your time. Don't start again, reiterating the facts from point A to point Z. No. Just go clearly on your arguments on issue 1, issue 2, issue 3, and then you close. But to answer your question, you have to budget for rebuttals as well, so that you're able to work within the time allocated.
I also want to agree with Victor that your time allocation means you do everything. You start your opening address, you make out your case, you do your closing remarks, including now your prayers at the end, and ensure you have time for rebuttals. So I guess this is a question that is addressed in the rules, and you must look at the moot court competition, or rather the moot camp competition rules again, to ensure you understand how the oral presentations are to be made and the time within which you're supposed to make your presentation. So just be clear on the rules, but budget for the time allocated. Don't go outside of the time the court has given you. You'll be safe that way.